Ho.
Thank you, Mr. Speaker. I got a slightly different statistics from Mr. Young's. The building and construction sector contributed around 5% to New Zealand GDP and employed about 7 to 8% of our workers. But that's covering the period from the year 2000 to year 2008. So I believe the sector would certainly have contributed much more and employed many more now with the Christchurch rebuild and a higher demand arising from the housing shortage in Auckland and other areas. As I said, the building and construction sector is vital for New Zealand's economic performance and our prosperity. The proposed amendments under this bill are very important. They are seeking to protect not only the head contractors but also subcontractors as well. The Commerce Committee asked for statistics on construction cases in the District Court and High Court. I understand that the Ministry of Justice does not collect such data, nor does Statistics New Zealand. Like the situation concerning the residential properties purchased by non-New Zealanders, where no one is collecting such data. There is this is another example that in New Zealand, no governmental organizations are collecting statistics in those areas, so are virtually flying blind and were in the dark. I am glad to learn that under proposals under this bill, and specifically in clause 31 of this bill, the new information gathering powers will enable the Ministry of Business, Innovation and Employment to gather data about construction cases in the courts. I thank the officials who made the reference to a paper written by Thomas Kennedy Grant QC. The paper reviewed cases on the primary legislation and summarized 177 court decisions. Of the summarizes that referred to adjudication determinations, it was found that in one case the court made a different decision to the adjudicator. In one case, a determination was held to be invalid due to procedural problems, and in 4 cases, the adjudicator was found to have breached the rule of natural justice. The references and analysis are very important and valuable to ensure that we introduce meaningful changes that are working in the industry. The adjudication process is important. The construction sector places significant reliance on the adjudication process. Other dispute resolution mechanisms, citizens, or measures available to the industry are either unsuitable or untenable, due largely to the cost and timeframes associated with the process. We've learned from the submitters, such as Registered Master Builders Federation, Certified Builders Association, Master Plumbers, Gas Fillers and Drain Layers, etc. Their members all place significant reliance on the adjudication process, and for some professional organizations, the adjudication process is commonly the sole way of resolving disputes under construction contracts. There are 3 further issues concerning the dispute resolution regime. The first 2 are in respect of adjudication process. Firstly, if the parties choose to use the adjudication process under the Act, the adjudicator's determination is binding on the parties but not directly enforceable. The Act requires the successful party to apply to the District Court if they wish to enforce the determination, and the District Court decision on enforcement of a determination can be appealed by either party to the High Court. So basically the problems are that the decisions are binding but are not directly enforceable. The avenues available to the parties are through, of course, appeals to the district court or the high court where appropriate. And secondly, new regulations have been made prescribing qualifications for adjudicators. So the common practice for parties is to request one of the authorized nominating authorities to select an adjudicator to determine their dispute. In order to provide clarity, the regulations are needed, and I'm glad to learn that our officials will work on the regulations after the passage of this bill. Thirdly, the Act presently distinguishes between disputes about payment and disputes about contractual rights and remedies. That distinction can be unhelpful. The construction industry, due to the nature of the profession, needs a dispute resolution system that is speedy, reasonably simple to use, and cost-effective. And I look forward to a further debate on this bill, and I commend this bill to the House.
The question is that the motion be agreed to. Those of that opinion will say aye. Contrary. Well, order. I never heard any member call. The question is that the motion be agreed to. Those of that opinion will say aye. Contrary, no. The ayes have it. This bill is set down for committee stage next sitting day, and the House will stand adjourned until 2 p.m. on Tuesday, the 8th of April 2014. May you all have a safe and productive recess.